Good afternoon, everybody. Thank you so much for joining us for our webinar on the application of our Protection of Personal Information Act to SMEs, and we are going to focus on small businesses. I think so many of you have been left out in the POPI compliance issues because everybody's focusing on the big companies, the big banks, and so on. But we haven't been focusing enough on the small businesses. And of course, there are no exemptions in terms of POPI for small businesses. So it definitely applies to you as well. So thank you very much for joining us. I'm Ira Gunning. I'm a director in our banking and finance department. And about 10 years ago, I fell in love with data protection. So this is basically what I do all day, every day these days. I'm joined by my colleague, Nicole Gabryk, who is an executive in our litigation department. And I call on Nicole when things go wrong, when the data breaches happen and when the cyber attackers phone us on Black Friday and holding your data ransom and so on. And then I'm very, very happy to also have my good friend, a client of the firm, and the founder of the NSBC, Mike Anderson, on the line with us. So welcome, everybody. We're going to start off by giving you a brief introduction as to when POPI applies. So we're going to tell you all about POPI, when it applies to SMEs and so on, and then we're going to take Q&A. So it's not supposed to be a formal lecture. We are definitely going to have some time for Q&A. And then I just do want to ask you that you just keep your questions to the end. Otherwise, we might not have time to go through all of them. And yes, we are definitely going to share the slides with you as well. So I know some people have asked if we're going to be sharing the slides with you. Absolutely, we will be sharing the slides with you. But just as an introduction, quickly, we are going to be telling you 5 things that SMEs should know about the Protection of Personal Information Act. I should probably have 6. And the first one is that you can call this piece of legislation anything you want. I still call it POPI because 11 years ago it used to be our POPI, and we all used to call it POPI, and old habits die hard. Nicole, who's obviously a lot younger than I am, she calls it POPIA, like the regulator. The regulator says we must call it by our sister, by the name of its sister act, PIA, the Promotion of Access to Information Act. Some people call it POPI, some people call it the POPI Act. It is all the absolute same thing. So what is POPI? POPI is something that looks like this, and you will see that mine is very well used. It's a written piece of law. That is what it is. It's a statute, a document that tells us all about privacy and what we should do as far as people's privacy is concerned. Okay, so moving on, I thought my slides were freezing, but they're not. Hallelujah, Nicole, they are working. So I'm going to be discussing the background and general application of the Act. I'm going to discuss when personal information can be processed. We are going to discuss the role of the information officer. We're going to give you a quick POPI checklist, and then we are going to discuss non-compliance as well, because I know everybody wants to know if they're going to go to jail, and I really don't think anybody is going to go to jail. But for background purposes, where does POPI come from? What is our mother? We are based on the EU Directive on Data Protection, which came out in 1995. It was replaced by the very famous, the celebrity of data protection laws, the General Data Protection Regulation, the GDPR, in 2018. So the GDPR is our sister, and the old EU directive is our mother. And the only reason I'm telling you this is if you don't want to incur a lot of legal fees, if you want to know how to apply POPI, you can always go and Google what the foreign regulators have done, because POPI says we must look at international standards. So we've got a whole lot of information made available at no charge to us on the ICO's website, the Information Commissioner's Office in the UK. And that is also where Nicole and I always stop when we do our opinions. That's our first stop shop as well, to see if they've already considered this, because they've been doing it for longer than 20 years. So every single responsible party in South Africa is supposed to be POPI compliant by tomorrow. So POPI is now kicking in after it started off as a baby in 2009. 12 years later now, it is finally becoming a full-fledged effective act tomorrow. So this has been a decade in the making, and yes, it is kicking in tomorrow. There was a bit of fake news that it's been delayed until February next year. Only one little subsection has been delayed. So definitely kicking in tomorrow. But please don't see this as a race that you now haven't made and now you're going to give up. It's actually a journey that is beginning tomorrow. So POPI is going to be with us for the foreseeable future. So if you haven't done anything towards POPI compliance, please rather see it as a journey that starts tomorrow. So when does POPI apply? POPI applies when SMEs or other companies or other organizations process personal information which is entered into a record, and this must generally, as a general rule, happen in South Africa. So if you're an SME in South Africa, POPI is going to apply to you. And it applies when you record, and that can be in any means or form. It could be you making handwritten notes, you recording on your phone, CCTV cameras, whatever goes into your laptops, hard copies of documents. So if personal information which is processed is recorded, that is what triggers POPI. So processing is absolutely anything with a verb. We could have said use. Processing is just something fancy for using information. So even if you're destroying information, that would be seen as the processing of information. And Nicole, I'm going to ask you to tell us about that London pharmacy, which is your favorite story about deletion of data and SMEs beware.
So interestingly enough, when we look at when things go wrong, and the design is not to scare everyone, but just to reinforce that compliance is important for all organizations, at the very first fine issued by the Information Commissioner's Office in the UK, the ICO, when GDPR came into effect after 2018, wasn't to a big corporation that had done something naughty. It was actually to a small pharmacy in London. And what they had been doing, and in their journey to comply, is they'd taken their old patient records from 2016 to 2018. They popped them into rubbish bags and put them outside in a bin in getting rid of information. And a member of the public had stumbled upon these records lying in the waste bin. And they reported it to the ICO's office, and they were actually fined, I think it was £180,000 back at that stage for non-compliance. And the issue was in the way in which they had deleted this information. Discarding, destroying, all needs to be done in a safe manner. And because it was sensitive information, health information, patient records, they weren't found to be upholding good enough standards in deleting records.
Absolutely. And the same would apply to, say, old CVs that you are keeping. And please, POPI is going to apply to old records. It's going to apply to old, new records. And if you are going to get rid of them tomorrow in a haste, please make sure that you are doing it securely. Now, I've already had a question on the chat. What is personal information? Absolutely. Thank you for asking that. That is the heart of today's session. What is personal information? So personal information, we've got a list of stuff like race and gender and sex and pregnancy and so on. But it is only personal information if it relates back to an identifiable person. Now, POPI is quite strange in that that identifiable person can be a living human being, or it could be an existing juristic person. Now, I say this is strange because our mother, the EU directive, and of course our sisters around the world like the GDPR, don't recognize juristic persons. They don't protect the information of companies and so on. But POPI does, which is very interesting. So we're not sure how this is going to pan out. But for example, you will see that a symbol of an existing juristic person would be seen to be personal information. Likewise, contact details would be seen to be personal information, whether it belongs to a human being or it belongs to a company. And Mike, I know you are very, very passionate about trademarks and trademark registrations. When should we be doing it and when shouldn't we? But I would like to hear your thoughts on the fact that a symbol, potentially a trademark, would be seen to be personal information. So if somebody steals our trademark, starts using it, it would be them using our personal information within POPI, and we would be able to go to our regulator and lodge a complaint. What are your views on this, Mike? Do you think this might help some SMEs?
Well, Ira, first of all, thank you very much for allowing us to be part of this. It's extremely invaluable session. And yeah, trademarks is a passion of mine, for many years now. And it's a positive passion because, of course, that, our intellectual property is the essence of our business. And but the important side is for an SME, and I know I've had a lot of engagement with SMEs over the past many years on trademarks. And the big concern has always been, if I go for the registration process in whatever class it may be, 2 or 3 years down the line, of course, it takes about that amount of time. But of course, the concern always comes in when litigation pops up. For example, especially if a big company wants to challenge your registration. And of course, we do know as SMEs, we can't go the legal distance financially in of course, defending that action. So many SME out there would just allow that to go ahead and avoid litigation. And I know you're going to bring some insight into this on the very positive side of the POPIA Act with regards to trademarks, that it's not going to be that way anymore, and it will allow many more SMEs to follow through on the registration process of trademarks. So I think there's a lot of development around this, and I think there's a lot more insights coming into this. So from your perspective, Era, to have a viewpoint on trademarks and a little bit of clarity around this would be pretty exciting news at this point.
Absolutely, Mike. And a while ago, we did a webinar with our IP department here at ENS as well. And of course, I'm not an intellectual property expert at all. And if anybody wants IP advice, I would certainly refer them to our IP department. But we do know POPI, and what is very clear in terms of POPI is that a symbol of a person, be it a human being or a juristic person, a small SME, would be seen to be personal information. Where it's going to take us, we don't know, because we would usually go and see what has happened overseas. They don't recognize this. So we don't really have any precedents to see where we can go with this. But I certainly think that there is room to argue that these disputes can land up in front of our information regulator. And I certainly do hope that that will assist SMEs. So I do think that we shouldn't only see POPI as the stick, but that we should also see POPI as something that is going to assist us with our privacy. And by the way, POPI includes these juristic persons here because we also give effect to our constitutional right to privacy, which applies to human beings and to companies. But incredibly importantly is if you look at this list of information, we get the ordinary information, which does include your symbols. We get contact details, we get names, we get things like criminal history, financial history, but this is all called ordinary personal information. Then you get the red flags like race, sex life, ethnicity, health information, belief, medical information, biometric information. And Nicole and I call that type of information, we call that red flag information. So our red flag information, like our race information, sorry, my slides are jumping around here, like our red flag information, there we need to be a little bit more careful when we process that stuff. So your ordinary personal information, you don't need consent. So you don't need consent to process it as long as you have a lawful reason. So let's say my lawful reason would be employment or procurement, or sometimes in some instances marketing, but I'm sure you may have heard that marketing is sometimes a bit of a red flag in terms of POPI. But we can argue these things are in our commercial interests, in our legitimate interests. It's in the legitimate interests of a third party. So when we deal with ordinary Black information, we don't necessarily need consent. But the minute we hit the red information, our lives become far more complicated, and we have to be a lot more careful with these types of information. So if you guys take home anything from today's session, it is to be more careful when it comes to special personal information. As long as you're not doing silly things, Black information would be fine. But the minute you hit things like race, health, religion, medical information, generally, unless we've got a clear-cut law that says we can process that information, we shouldn't be touching that stuff. There are some exceptions, but they're complicated to apply in practice. So be very careful of special personal information. Likewise, information of children, kids under 18, Don't touch it without parental or guardian consent. Now, the absolute heart of POPI are the 8 processing conditions which sit in Chapter 3 of POPI. Now, it's Nicole and my pet hate when people say to us, write a short little opinion, a paragraph, and tell us what you're doing is POPI compliant. You can never do that. You can't go and certify somebody and say you're POPI compliant, because POPI is a journey. And that journey that starts tomorrow would always involve 8 processing conditions. So whenever you touch somebody's personal information, there are 8 conditions that you have to comply with. The first one is accountability. Accountability means comply with POPI and be able to demonstrate compliance with POPI. And yeah, I'm quite concerned, Mike, about our SMEs, because I'm concerned they don't know about POPI. And you're not going to be able to demonstrate compliance with something that you don't know about. Anything you want to add here, Mike?
Well, yeah, thank you. Well, first of all, what we do know in our recent research and findings report is that most, above 80% of SMEs don't know anything about the POPI Act. And I think that the big concern is from tomorrow, it's quite a scary process, and we're trying to take that scariness away. And like you say, what's pretty exciting, what you just said, tomorrow is a journey that begins. And I think that's going to kind of alleviate a lot of the pain from SMEs out there. Because I think that the important thing about the POPI Act is that there are very few SMEs who don't want to comply. They just don't know what they need to do to comply. They're afraid it's going to cost them a great deal of money to comply, and it's going to take them an enormous amount of time. And as we know, time for an SME now, especially now during the pandemic, is of the essence. So these are the pain points that's coming out. But the intention to comply is positive. I think what is really needed is a firm guideline of what do I do now to start the process. Because I think what you've said earlier is a very positive point, that everyone's wondering how they become compliant by tomorrow. And of course, that's not the case. And I think, as you say, that's the journey. And I think that's refreshing to hear.
Thank you, Mike. So the next 3 processing conditions is, they all go hand in hand. So further processing limitation, and purpose specification, in a nutshell, say the following. Don't touch information unless you've got a reason for it. So first, work out what is your purpose. Don't just collect information for no reason. Work out what your purpose is. Check that your purpose is lawful. Then only collect as little information as possible to fulfill your purpose. Don't go and collect things that you do not need. So collect as little information as possible to fulfill that purpose. I do see your hands up, participants. We will have time at the end for some questions, but we've got about 646 participants on the line. So let me just get through when it applies, and then absolutely we are going to give you some time to ask questions. So have a lawful purpose. Collect as little information as you need to meet that purpose. Don't ask people for stuff that you don't need. And then when you store the data, store the personal information, only store it for as long as you have a lawful business to store it, or if there's a law that says you must keep it. Don't just keep information, all your information, indefinitely. Now, I know that a lot of you are going to say to me, but we've got a garage full of information, and we're now worried because POPI is kicking in, and we're working so hard to try and make money at the moment during COVID, and to make ends meet. We don't have time to go and sit and look through all these documents and work out what we must keep. POPI does recognize that you can restrict information, basically pack it away and keep it safe and leave it there until you do get the time to look at that information. And then you can still use it for purposes of evidence or proof if you need it. But I just want Nicole to tell you about the pitfalls in keeping all this information for just in case.
So, when we look at what we have to do with information, the first thing we always need to say to ourselves is, why do we have this information? So keeping things just in case you might need it somewhere along the line is not a good purpose for your reasons. The other thing is that for as long as we hold on to information, as long as it's in our possession, we are seen to be processing this information, which means we are liable for this information. If anything happens to this information, and I'll talk about data breaches in a bit, if something goes wrong with that information, then we're liable for it and whatever happened to it while we were looking after it. The other thing is that you'll see, Ira will touch on these now, is data subjects have a right to ask you certain questions about what information you have about them and what you do with that information. In that context, how are you going to be able to tell people what you have if you don't yourself know what information you're holding on to? So in the fullness of time, it is important that you start thinking about your historical records. POPIA doesn't tell us that you may only keep records for 3 months or 3 years, but it does remind us that we have to keep records only for as long as we need them. We have to look after them, and we must keep the information up to date.
Thank you, Nicole. And then anything that we do with the information going forward must be compatible with the reason for collection. So don't collect information for COVID tracing purposes and then do direct marketing with that data. Information quality, you need to keep your data up to date. And again, to go back to Nicole's point, if you just keep information for just in case, you're making your life hard, because you are supposed to then take measures to make sure your information is up to date and correct. If you send emails out and they bounce back, you can't just leave it. That would be a POPIA breach. You would have to take some sort of action when you see your details, your contact details, and any other personal information is not accurate, is not up to date. Openness. It is vital that you tell data subjects who you are, what information you collect, why do you collect it, who do you share it with, do you send it overseas, and if they want to fight with you, they can go to the information regulator. We do this in a privacy or privacy statement, notice, or policy. And I'm sure so many of you saw these going around in the last week. People telling you, we just want to tell you how we collect your information and how we use your information. POPIA is kicking in tomorrow. So if you haven't seen these, you'll be seeing a lot of them going around, and that is to comply with this condition of openness. Security safeguards, you are our data breach expert, Nicole. What practical advice do you have for our SMEs?
So on this point, it's quite interesting to note that if we look at last year's statistics coming out of Europe, for example, 30% of all data breaches involved SMEs. So you can see that, and Mike, I'm sure you can speak to this as well, the types of information that SMEs hold is as important as large companies. They could hold reams of important information.
And credit card details.
No, credit card details, health information, employee information, all that information is there. So it's certainly interesting. But, you know, what's very important with this section, security safeguards, and where people say, well, how do we comply with that condition? One thing that is clear from this is that it says that we have to apply reasonable measures to look after our information, but the measures must be technological and organizational. So what does that say to us? It says to us, firstly, it doesn't only apply to digital information. Okay, don't forget that POPIA applies to our physical records as well, the paper we keep lying around our offices. So this is not just an information age piece of legislation, it's also relevant for the physical paper we keep around the office. And there are many things that SMEs can do from a practical perspective. It doesn't cost big money to demonstrate these kinds of compliances. So, for example, think about where and how you store your paper, okay? Is it safeguarded? When we transport information from our offices back to home, or if we work from home, where do we leave it lying around? When we use printers, do we look after those printers through a printer policy? For example, if we print something, does it lie there for anyone to use? Do we have clean desk policies? These are all simple measures that people can adopt, which doesn't really involve a very big cost. Then we turn to our technical measures. Now, the first thing I say to people is technical measures doesn't only mean fancy IT security software. Yes, it can mean that. It can mean multi-factor authentication and VPNs and encryptions. But the simplest way that we protect ourselves is firstly through our own behaviors with our devices. First question I say to everyone is, when last did you change your passwords? So if you're sitting on this call now and you haven't changed your passwords, your personal passwords, your banking passwords, your email account passwords in the last 3 months, go and change them. And make sure your passwords are complex passwords, okay? Ira, do you want to mention that example where there was a breach many years ago? Ira loves the story. What were the two most common passwords?
I'm going to test Mike on this. Mike, with a big Ashley Madison breach. And guys, this was a dating website for extramarital affairs, and they were hacked. And they re-identified all their passwords. And I asked Nicole this, and she got 50%, Mike. What would you think would be the two most common passwords used?
Well, firstly, Ira, I wasn't on that website. I would imagine people's birth dates and their children's birth dates and 1, 2, 3, 4, 5 or 5, 4, 3, 2, 1, and probably in the region or in the line like that.
Absolutely, you score 50% like our
you and
cyber specialist there too. It was 1, 2, 3, 4, 5, 6, and password. Password was the second most used password. So please, if your password is password, go and change it immediately. And then just the last thing I wanted to mention on the previous slide is data subject access requests. And you can use them in your favor as well. So when somebody phones you and you get those irritating direct marketing calls that you don't want to hear from again, then you can say to them, I'm doing a data subject access request in terms of section 23 of POPIA. Where did you get my details from? And I'm exercising my rights under section 24, delete my details. So you can use that in your day-to-day life as well. But data subjects can now come to us and say to us, what information do you have about me? What do you have about me? And where did you get it from? Who did you share it with? And if I'm no longer authorized to have it, they can tell me to delete it. They can tell me to forget about them, delete everything I have about them. But I've been trying for years to tell my bank to forget about my mortgage, and they won't listen. So if they've got a stronger right than us, they can tell us to go away. Just so that you also know, if you send information out of South Africa, it's stringently regulated. Security compromises, Nicole, I'll let you speak on that a bit, heavily regulated in terms of POPIA, and so is direct marketing. Direct marketing, very, very, very stringently regulated in terms of POPIA, unless you are a direct marketer by telemarketing. Telemarketing not as stringently regulated. A side effect of POPIA is going to be that we are going to see more telemarketers, because telemarketing not as stringently regulated as our electronic direct marketing, such as SMS and email. Nicole, you want to talk to us about data breaches a bit?
Right. So what is the basics we need to know about data breaches? The first thing we want to know about a data breach, okay, is that it's not only the sophisticated cyber attacks that we tend to think about, the hacking and the ransomware. Yes, that happens, and I think 40% of hacking attempts last year were also targeted at SMEs. But really, it's as simple as this. We hold personal information. If that personal information lands up in the hands, or we think it's in the hands, of somebody who shouldn't have access to it, it would constitute a data breach. So they say when there's an access or disclosure by an unauthorized third person, that constitutes a data breach. So let me give you some practical examples that we don't have to get stuck in the theory of it all. It means if I'm sending an email to Mike and I attach an invoice to him, but actually I send it to Ira, and in that I include Mike's address and his bank details and how much he owes me and what he's bought, that would constitute a data breach, because I'm not entitled to send that information to Ira. If I send an email to everyone in a organization or out of an organization, and I CC everyone into that instead of BCCing them, I would be disclosing all their email addresses. So it's these kinds of things that we do on a day-to-day basis that could constitute data breaches. Loss of a laptop. If we go and we stop at the petrol station and our laptop's stolen out of our car and it's not encrypted and it doesn't have proper protections on it, that information could constitute a data breach. So yes, it's these sophisticated attacks, but it's also a lot softer in terms of the issues that it relates to. And so if that happens to you, you have to do something. You have to report it to the regulator, you have to report it to the affected data subjects, and you have to do so quickly.
Thank you, Nicole. And then, Mike, if you don't know that, you are the lucky winner of the Information Officer title for the NSBC. So every single entity in South Africa must have an information officer. It's mandatory. And it is by default your CEO. And your CEO can go and authorize somebody else to become the information officer. But what you would need to do is go to the information regulator's website, and you will see that there's a guidance note there on information officers. And they've got a template in there that you can use, or that you must use, to authorize somebody else if you don't want the CEO to be your information officer. And then you have to register your information officer with our information regulator. Mike, have you done the registration before the portal crashed, or were you one of the persons that had the crash when you tried to register?
Well, I think that we were lucky on that one, and we weren't involved in the crash, but I know that that procedure has been done, and I'm certainly not going to be the information officer. And that will be designated to someone else who's more competent and more efficient than myself. But we weren't part of the crash, thank goodness.
So if you were trying to register your information officer, you know, the portal wasn't working. It worked for a little while and then it crashed and it wasn't working. And then when you went back, it said your ID number was already used. And if you did it during load shedding, they would have said your ID number has been used and you couldn't register and you couldn't fix it up. The regulator has admitted that they've got issues with the portal, and they've said that they are fixing the issues, and they said that they are not going to take any action against any company who hasn't registered their information officers by tomorrow. So if you were one of the people really battling there, don't worry, no action will be taken against you for not registering. So a quick accountability checklist. Now you will note we say by the deadline, but I have explained to you, ideally by the deadline, we wanted to have these things in place. But if we don't give up. Try and get yourself as close as possible to compliance. And if it is not there by tomorrow, then do it as soon as you possibly can. So what you need is you need your information officer, which is the head of your business, unless they authorize somebody else. And you can just Google information regulator, information officer guidance, and there's a nice freely available document setting out to you exactly how to do this. Make certain disclosures to your data subjects, who you are, what information you use, why do you use it, and do that by means of a privacy statement or policy or notice. Many free templates available there as well. Make sure it complies with the use section 18 of the Act as a checklist that will tell you what must go into your privacy policy. Now, my favorite quote is, again, Steve Jobs saying, tell data subjects over and over again what you do with their personal information. Use your privacy statement, chuck it in wherever you can, at the bottom of your email signature, on your website if you have one, disclaimer notices that you have up. Always reference your privacy policy or privacy statement, because then you keep on telling data subjects what you are doing with their personal information. You have to have a POPI compliance framework. POPI doesn't define what it needs to look like. You don't need to have a Rolls Royce. If you're an SME, you can have a Beetle, but have a plan in place on how you're going to roll out POPI compliance within your organization. Develop a data protection policy, setting out how you are going to deal with people's personal information, practical things you will allow and will not allow. You have to do personal information impact assessments, but POPI doesn't say to us when these need to be done. The main reason we do them is to identify when we use red flag information, when we transfer information to third parties, are we sending information overseas, and so on. By end of this year, everybody in South Africa would have to have a POPIA manual, including SMEs. But very recently, the POPIA exemption, the Promotion of Access to Information Act exemption for entities with less than 50 employees has been extended. And I think it expires in December, Nicole, is that correct? And they said that's the last time they're going to renew the exemption.
That's right.
So by December, we're all going to need a POPIA manual that must go up onto your website. You need to have some sort of policy that deals with data subject access requests. When people say to you, I'm exercising my rights to know what information you have about me and I want copies of that. You need to do some sort of awareness and training. It doesn't have to be a 3-day course. It could be making your staff watch webinars such as this one. And then in certain instances, you need prior authorization. We're not going to have time to get into that. But Nicole, I'm going to ask you just to speak about operators for 2 seconds.
So what's very important here is that the Act distinguishes between 2 concepts for us, and they call the one concept a responsible party. Well, the responsible party is your company. Now, there have been a number of questions there about whether a juristic person is a company. Yes, a juristic person is a corporation, it's a company, it's a trust, it's a not-for-profit organization. It's all of those kinds of things that all count as a juristic person for South African law purposes. And the responsible party is the person who has to comply with this act. Either, normally your company or your trust or whatever it is that you've set up in terms of the vehicle that you operate from, sole proprietorship or however you've structured your business. But the Act recognizes that we can't do everything ourselves. And so it recognizes this concept that they call an operator. In Europe, it's called a data processor. But what that is where we give information to someone to do something on our behalf with that information. They would be an operator. Now, it's not in every sense of the word. So, for example, the person, any third-party supplier you work with is not necessarily an operator. If they come there and they pick up your rubbish and off they go, unless they're picking up those sensitive records that we spoke about for the pharmacy at the start of this, they would not be an operator. Likewise, if you came to Era and I, for example, as a lawyer, we're not an operator, we're our own responsible party. And so the action of sharing data doesn't constitute an operator relationship. It's only when we give information to someone to perform a particular function with that information. Good examples of those are IT service providers, payroll administrators, courier companies. Those kinds of issues would be operators. And why is it so important? Because the Act says 2 things. One, it tells us that we must have a written agreement with our operators, okay? So we have to put in place a mechanism to look after, to secure our information in the hands of those operators. And secondly, we are liable for the actions of those operators. So when they do something that they shouldn't be doing, or a breach happens, or it causes damages to our data subjects, we as the responsible party would be liable for the actions of those operators.
Thank you, Nicole. And then Mike, one of the comments we have here in the chat is this sounds absolutely crazy for micro businesses. It sounds like it's going to be a nightmare for SMEs. What are your thoughts on it, Mike?
Yeah, it's a very good question. It is, I think every new thing, sometimes could be a nightmare. And I think that we shouldn't look at it as a nightmare because we cannot do anything about that. And I think we've got to seize it like, a lot of these SMEs are risk takers. They've failed many times. That's the essence of succeeding as an entrepreneur. I'm passionate about that subject. So we've got to look at it in a similar journey, is that it's here to stay. We've got to try and keep it as simple as possible, use it as a journey and tackle this. I would like to have seen exemption for this for a certain amount of under employee size. We do that with a lot of other areas around the Labour Act and taxation, and we will see what we can do here, working closely with the regulator to see how we can alleviate this somewhat at the moment pain from the SME. But I agree with that. I don't know who it was who put that question forward. It is. Look, I think we've got to take it seriously. We've got to take it seriously, and we've got to do what we can to comply. That's in a nutshell. But yes, it does appear to be a kind of a nightmare, but I think this kind of webinar has certainly alleviated a lot of the pressures and the perceptions. But I think that, in life, the more we know about something, the easier it becomes. And I think that my urge to SMEs out there, become extremely familiar with the Act, get your team around you to have equal familiarity with the Act, and do as much as you can to learn everything about it, so it can become an easier rollout as opposed to the perception that it is now. So I do have empathy for SMEs in South Africa because it is probably at the moment it's daunting. It's daunting, and the perception, as I said earlier, it's time consuming, and of course, for many, we're going to have to change a lot of our mechanisms, a lot of our sites, and that can cost money and equally important time again. So I just think that we've got to adopt it positively because that's the choice that we have.
Absolutely, Mike. And as far as cost is concerned, there's a lot that we can do that will not cost us anything, like reading the Information Regulators Guidance Notes, seeing how the similar act to us, our sister, the Data Protection Act and the GDPR, were implemented by the ICO in the UK. So by simply Googling ICO UK, you'll go to a fantastic website that will give you a lot of practical guidance and some free templates and so on to help you as well with your awareness campaigns and so on. But that being said, I cannot promise you that compliance here is not going to cost you anything. On average, SMEs in Europe spend between €1,000 and €50,000 on compliance with the legislation. And I know I'm the bearer of bad news here because we're in the COVID pandemic and everybody is very concerned about that. But we don't have to take all of that out, and it doesn't have to right now, and it doesn't have to be an all or nothing approach. But what the message I'm trying to relay today is, don't decide I'm just not going to comply at all. Focus on what would be most important, like keeping your data secure. About 80% of issues under data protection laws happen because of your own employees using CC instead of BCC on an email, not locking documents away, let it lie around in a coffee shop, using free Wi-Fi in a coffee shop, and so on. So there are certainly things that we can implement that would be free. And then in the long run, the things that would cost us, we certainly cannot get away from that altogether. We've had a lot of questions about the POPIA manual. What if I'm only a company or an SME with three people in it, 3 employees, a founder and 2 others? There is talk of an SME exemption for your POPIA manual, not for POPI altogether, just for your POPIA manual. So we do know that you are exempt if you have under 50 employees until December this year. Now, there is talk of an SME exemption coming, but we haven't seen anything in writing yet. So this may very well be fake news. We don't know. So ICO UK, yes, that is the ICO UK. And then we were asked, will we actually make our slides available? Yes, we will share our slides with you. No problem at all. And you can use that internally to create awareness. Nicole, any other practical tips that you want to give here while I'm reading the questions that are just popping up so quickly I can't read them?
There's a lot of questions here around WhatsApp and what's happening with WhatsApp at the moment, and the consents around use of WhatsApp and how we go about using it. If you go back in the fullness of time to ERA slides that she shared with you, and yes, we'll share those with you, and look again at the definition of personal information. We spoke about the 2 different categories of what it means. We did the black and the red information. Our red flag information is our special personal information. And the general rule again with special personal information is we need consent to use that information, okay? So where WhatsApp gets tricky, or any of these social media type platforms, and I'm talking in a business capacity, remember, POPI doesn't apply to our personal household activities. Our day-to-day, I've got my book club and I'm sending ERA a message to say book club's at 8 and want to see you there. That doesn't apply. It also doesn't apply to law enforcement, and it doesn't apply to journalists. We're talking about in our business sense, business capacities here. WhatsApp, for example, as one, and likewise for Signal and Telegram and Messenger and any other online messaging platform that you may use. It contains a lot of personal information, or potentially could contain a lot of special personal information. Take, for example, your profile photo. Go and look at your own profile photo if it's you and your child, for example. that would have children's information, and likewise photograph information could be special personal information. So it's not true per se that you have to have consent to use WhatsApp and be part of WhatsApp groups, and there's a lot of these messages snowballing out of control. But do think about your access protocols and make sense at this stage to reconfigure your groups that you have on WhatsApp. And where you have group chats within a business environment, send out new links to people that they can consent to be part of it. And instead of getting them to consent to do certain things, remind them about their own security settings. So, for example, on WhatsApp, you can turn off access to your photos and your name in group settings. So it's these kind of hygiene practices we can do that there's no regulation in POPI that says you have to get consent for WhatsApp. Don't get those confused. It's just about thinking about the types of personal information we use.
Absolutely. And that message that was doing the rounds this morning saying, in terms of the POPI Act, you now need this consent to use this WhatsApp group. That certainly is not the case. What they try to achieve there is when you're using special personal information or information of children under 18. For example, if my status is a picture of my little girl, then you could inadvertently be processing information of my child, and you should have consent to do so. So that is where that came from, and that message doing the rounds at the moment, I don't think is all that well written, because it is not achieving.
If you think about the fact that there's exceptions in the Act for information put into the public domain. Okay. Now, when we place our profile photos onto a chat group or whatever it is, we're doing so by placing it into the public domain. And so likely you don't need those consents and things. So I think we must be mindful of what's doing the rounds, these panic messages happening anyway, Mike, and I'm sure you've seen a number of these. I don't know if you've also received emails to click on links to register details for POPI, and as an IT security lawyer, terrifies me. What are your thoughts, Mike?
Well, absolutely. I think I get it daily, like proof of payment, please, it's attached. And, it's not a proof of payment, but of course, everybody wants to see a proof of payment in an SME. So the majority will click on that. So, yeah, I think that it's got out of hand. It's exponential. And I mean, these days, you don't know what to click on and what not to click on. So I have a personal rule. I just don't click on anything until someone really phones me.
I agree with you, Mike.
So, and I mean, especially when it comes to financial issues, isn't it? You've inherited $5 million from your great uncle in Ireland, and of course, people will click on these things. And I think that I've learned that a couple of years ago. So I don't do that. And my big encouragement, I'm sure most of our SMEs out there don't do that either, but it's just not to open anything until someone breathes down your neck.
Absolutely. And Mike, we've got a question in the chat about what about details on invoices? What about personal information that we get on our invoices? Practical measures. How would you guys keep it safe at the NSBC?
Absolutely. Look, we've got these cloud accounting platforms that are all pretty compliant and all that. And we've looked into that. And, you've got your big guns like Xero and of course Sage and all these platforms, and it's pretty safe in the cloud with login and passwords. So, we store them in the cloud. We no longer print these things out. I think, well, most people don't anymore. They store that in the cloud. So, and I think, but what you're taking from you, Nicole, this webinar, is that my whole perception about this has changed. I like the words of Richard Branson: adopt the magic of tiny steps, and possibly with the POPI, have a whole bunch of little steps to get you to where you want to be, as opposed to this one big elephant, that scares the hell out of you. Rather just take it every day, the magic of tiny steps, and eventually you're going to get to the top of the ladder and achieving your objectives around POPI like anything in business. So yeah, we at the NSBC, started, I've known you for a couple of years, Era. We've started just a year ago, because we all thought this was coming in a year ago and there was an extension of this. And so we started the processes, and we adopted the magic of tiny steps. Every day we did something very small that moved us in the right direction. And we will continue that, because we're certainly not POPI compliant as yet, but we extremely vigorous on our journey towards that. And I think that offline yesterday I asked you the question, how many companies are POPI compliant? And I think there's an alarming amount who are not, big and small. So, but I think that we can't take that as a great answer. We've got to take it as something that, we just look around us and look at my desk and look at things and what am I doing? And I think you've made me very aware. You made me aware of my behavior from now on, personally and with our organization. So I think that's the big message for me that's come out today. And I think that a lot of SMEs would agree to that. And I think that equally so.
Absolutely. And if you get something that they call a data subject access request, but it's from some sort of Gmail email address that you cannot verify, don't just go and send a lot of personal information to them. Always check, who are you dealing with? Why are they asking for this information? Verify who you are dealing with. And I think while we have about 10 minutes to go, we'll take some hands. I see there are lots of questions, but I know we had 2 people raising their hands and really wanted to ask something. If you still want to raise your hand and ask the question with absolute pleasure, you can do so. Then there's a question, Nicole, I'm going to ask you this. How do we appoint a reputable company to assist our business? Where do we find them?
I don't want to self-promote us, but please do get in touch with us. Ira and I host these webinars on a regular basis. Even if you perhaps can't afford the compliance packages, we have designed some compliance packages for SMEs that are reasonable in terms of costing. If you can't afford those sorts of costings, then at least try and attend some of these webinars and seminars that we have on a monthly basis. There's a lot of questions I see that have been popped into the chats about direct marketing. Ira runs direct marketing workshops on a monthly basis at a small cost to you. So by all means, register. We spend about 3 hours just tackling direct marketing and what that means. Information officers, we do information officer training. Happy to offer some complimentary slots to some people as well, where we've got slots available. So get in touch with us. We're not trying to fleece you for money here. It's a case of we're trying to provide you with as much information as you can. And little things like, people were talking there about POPIA manuals and how can they get a POPIA manual? Go onto the Human Rights Commissioner's website. The free precedence for a POPIA manual is there. It's in the legislation. You can download it. It's an active step you can take. A lot of questions about free privacy policies. Well, our information regulator hasn't made any of these available locally, but under the ICO in Europe, for example, there were a lot of free policies and things floating about. So try and take those proactive steps to do these sort of general compliance issues.
Mike, anything else you want to add here from the NSBC's perspective?
I think that, the insights have been amazing. And I think that, for many of our SMEs, SMEs generally don't have the access to organizations and people like you. So I think that we're certainly grateful for these insights. And I think that we must continually follow you guys and see what's coming up, and more webinars and downloadable guides. And I think what this has done is put us in the right direction of where to look, and what to do, and help us on that journey. And I think that's the big question we're getting from SMEs. Where do I start? What do I do? How do I become POPIA compliant? And like you said, that everyone's compliance is different to another. There's no perfect compliance, isn't it? And so I think that you've put us in a great direction of what to do and where to go. And the big question is, we're getting quite a bit of this. What happens if I'm trying my best to become compliant, but what happens if I get caught because I'm not compliant? What are the penalties?
Yes, I'm going to get to that now. Just to mention to you, we had so many questions on direct marketing. Direct marketing by telemarketing, not as stringently regulated as direct marketing by electronic means, such as SMS and emails that you send out. But in a nutshell, please make sure you've got proper opt-out mechanisms, and you don't go and contact people who opted out. That is where your huge risk lies. That by itself is not going to make you compliant. There's more that you need to do. Telemarketing, not as stringently regulated. If you've got a lawful reason for having people's contact details, you don't go buy a database that comes from somewhere dodgy, you should be okay. But honor your opt-outs. And also electronic direct marketing. I can't stress how incredibly important it is to manage your opt-outs. Penalties, non-compliance, Nicole.
So Penalties can mean two things. One, there can be fines of up to 10 million rand imposed. Remember, there's a number of factors the regulator is going to take into account in imposing a fine. So if you're an SME, it will be considered. The steps you've taken towards compliance will also be considered. COVID hardship would be considered. So these are all things that you need to demonstrate in any potential penalty. You can bring it down through showing the steps that you've taken. The other thing is that there's obviously rights and remedies for data subjects to sue people that have caused them harm from data breaches and non-compliance with the Act. So that's an option. I just want to add two things before I hand back to you, Era and Mike, for closing comments. One is there's been a few comments about COVID logbooks and those things. I just want to say this generally for SMEs and logbooks and for anyone that uses physical logbooks. Don't leave those things lying around premises. In fact, don't use them. Find a different system. If it's slips of paper you keep in a filing system or a digital online application or something, divert to that, because logbooks that you fill in and it's got Mike and Era and everyone else's name and ID number above me in a list, that would not be in compliance with POPIA because all that information would be lying there. So with our COVID screening and all the things we're doing at the moment, be extra vigilant with those sorts of pieces of paper. Okay, generally it's going to have health information, which is sensitive information. And then finally, you're welcome to follow Era and I on LinkedIn. Just look for us. We post updates on POPIA and developments in this space all the time. And there's some articles and things that may assist you as well.
And then we've got a question here. How will SMEs assess whether we are POPIA compliant? Can you get some sort of certificate or link? There is no proper certificate that can tell you anybody is definitely POPIA compliant because it's a journey. It is not something that you can assess on one day and issue some sort of audit and saying you're absolutely fine. It's a journey. So if you're looking for some sort of website where you can go and check who is POPIA compliant, that does not exist. So any last remarks from you, Mike?
I think, Era, you've said it all. And I just think that, what we will continue to do is that, on our journey, our continued journey, keep that kind of logbook and prove what we have done to be as best as compliant as we can. And I think that gives us a refreshing way forward with regards to the Act. And my encouragement to SMEs is, move from here in a very positive and proactive way. And, the finest form of education today is self-education. And there's lots of opportunities to self-educate in the way forward with regard to the POPIA Act, and have that paper trail or that digital trail on what you're proactively doing for you and your team. And I think in that way, there'll be a great outcome.
Absolutely, Mike. So just as a few final words from me, Nicole, I know you've said your final words there. We will be sharing our slides with you. If you're interested in hearing more about our POPIA Toolkit, our contact details will be on our slides. Please let us know. Very happy to share pricing with you as well. But of course, we don't want to spam you and just send it to you without having your direct marketing permissions. In a nutshell, make sure you do everything you can to keep your data secure. Change your passwords, like Nicole has said often. Make sure you don't leave documents lying around that may contain any form of personal information. When you're processing special personal information, you'll find a comprehensive definition of that in Section 26 of the Act, including race and health information, information of children. Be extra careful. Don't use it unless you have a proper reason to use it. For any information going forward, make sure you've got a purpose. Why am I asking for it? If you've got some sort of application forms, onboarding forms, don't ask for stuff you don't need. These registrations, when you visit a company like Nicole was speaking to, don't use them. So unless you really, really need them, make sure every single thing you ask for, you absolutely need. And then you keep that stuff secure, knowing also that everything you take down could be asked for a copy of by data subjects. There are some grounds for refusal, but see that as the general rule and build in consent for your red flag information. I think those are the main take-home points from today. And direct marketing, if you are not going to be properly POPIA compliant, at least make sure you've got strong opt-outs. And if I was an SME and I had 10,000 Rand to spend on POPI, I would make sure I've got a very, very good privacy policy in place. That is the number one thing that I will make sure I've got in place. And from our side, thank you very, very much for joining. Our contact details will be shared with you. Mike, thank you so much. I know you're very busy. You ran another very big webinar this morning as well. Thank you for making time in your busy day for us. Thank you, Nicole, and thank you, everybody.
Thanks,
for joining.
everyone. Bye.
Cheers.